I am Michael Cahill. It is currently my privilege to serve as Dean here at Brooklyn Law School, and I am delighted to welcome you to this evening's event. I'm partly pleased to be here as a recovering health law teacher myself. So in that capacity, I am familiar with the problem that is addressed by Professor Sachs and Landman's book, which is a significant one. So I am acquainted with the problem of iatrogenic injury and well acquainted with the fact that legal innovations are needed, as their book claims, because the current law as it exists is inadequate to respond to the problem that they are addressing with this book. So I'm really delighted that the book is the occasion of our being here, and I look forward to a very enjoyable conversation. Very happy to welcome Professor Sachs here, but particularly excited, not really to welcome Stephen Landsman, but just to say hello, because Stephen is already a long-standing member of our community, having been a recidivist visitor here for quite some time. I was trying to figure out, indeed, how long we had had a relationship with Stephen Landsman, and I know it goes back at least to the fall of 2010, because I have a receipt from my first semester as academic dean for taking visiting Professor Steve Landsman out for lunch. So I know that he has had an ongoing relationship here for the last decade. And notwithstanding that he has been a visiting professor for that time, that title really belies the extent of his engagement with and connection to our community. He has been a fully committed and invested member of our faculty and has really contributed a great deal to the life of the law school, to our faculty life, and certainly to the lives of our students. And we are deeply, deeply appreciative of that ongoing relationship. So I want to thank him for his presence here this evening and on so many other occasions at Brooklyn Law School. And really pleased to have this opportunity to engage with his intellectual work, as well as thank him for all of the other contributions that he makes at the law school. But without further ado, let's get the conversation started. And let me turn things over to the director of our Center for Health Science and Public Policy, as well as our Associate Dean for Diversity, Equity, and Inclusion, Professor Karen Porter, who I'm sure will say some further welcomes and thank yous, but many, many thanks to Karen for her role in putting this event together. And without further ado, here she is, Karen Porter.
Thanks very much. Welcome, everyone. I am really pleased to invite you here to join us this evening for this wonderful opportunity to discuss this new book that both Professor Landsman and Professor Sachs have written. The book, I am going to do what they will not do, is sort of put it up for you. Closing Death's Door, Legal Innovations to End the Epidemic of Healthcare Harm. It's a book that's produced or published by Oxford University Press, and it's just out now. I would be remiss to not tell you that it's available at Amazon and at Barnes & Noble. I've had the opportunity to read it as one of the first people, I think, to receive a copy, and I was really excited about that. I'm really happy to be here with you tonight to help them tell you a little bit about this project that they've been working on for some time. I want to just begin by not only saying welcome, but by also just introducing the authors to you in a little bit more depth. I'm going to start with Professor Michael Sachs. Professor Sachs is the Regents Professor at Arizona State University, where he is on the faculties of the Sandra Day O'Connor College of Law, the Department of Psychology and Law, and the Behavioral Sciences program, and is also a fellow in the Center for Law, Science, and Innovation. Previously, he was a faculty member at the University of Iowa as the Edward F. Howray Professor of Law and Professor of Psychology. For decades, he's taught appellate judges in the University of Virginia Law School summer program, LLM program, trial judges at Duke University's judging science program, among many other accomplishments and opportunities to actually give instruction on very important and innovative areas of the law. His research and scholarship has basically spanned a range of topics, the psychology of decision-making in the legal process, the behavior of the litigation system, science, and other expert evidence in the law, legal policy related to iatrogenic injury, which is much of what we're going to be talking about here today. I want to now just sort of turn to my colleague at Brooklyn Law School, Professor Stephen Landsman. As Dean Cahill has already informed you, he is a regular visitor with us at Brooklyn, but he is also the Clifford Professor of Tort Law and Social Polity Emeritus at the Paul University College of Law in Chicago. He's a graduate of Harvard Law School and the author of 6 books and more than 70 articles. His most recent books concern medical era, the challenge of crimes of the Holocaust, and the merits of the American adversary system of justice. He's an expert on the American jury. His scholarly articles examine the history, value, and workings of the jury, and he was the reporter responsible for drafting the American Bar Association's principles for juries and jury trials. He has many other accomplishments, including being an active member of the bar. So with that, I want to just turn a little bit to our program for today. And basically just give you a little bit of a sense of how we're going to proceed. So we're going to start off first by hearing a little bit from the authors. At some point, we will be inviting Professor David Hyman to come and join the conversation with us. After that conversation has taken place, we're going to be inviting questions from the audience, and I would advise you to use the chat or to use the raise your hands function, at which point I will recognize you and invite you into the conversation. We chose to do this as a regular Zoom meeting in order to enable the authors to have some engagement with you, the audience. And we thank you for showing up, for being interested in this program, and hopefully, for being active participants with them as they introduce this work to you and discuss the many issues that it raises. The last thing I think I'd like to say is that I'm asking everybody to keep themselves on mute so that we can spotlight the speakers and have everybody sort of focused on the conversation that they will be having with us this evening. So with that, let me just say that I very much enjoyed reading the book, and I kind of paused a little bit before I said enjoy completely, because the book is arresting, right, to read. Not, I think, because iatrogenesis is something that's new to me, but I think that much of what's presented in the book is actually new in terms of the volume of information about how significant a problem this is in our medical community here in the United States. So I think we're going to have a very interesting conversation in bringing out some of those concerns. I want to just sort of start by highlighting the fact that one of the things that the book makes very clear is that after heart disease and cancer, the third leading cause of disease in the United States is avoidable injury or infection resulting from healthcare itself. That is, I think, a startling starting point for all of us. I want to begin the conversation by turning to Professor Sachs and to Professor Landsman to really just ask them, how did they come to this project? And what are the main takeaways that we should be taking from the conversation?
This might be interesting because Steve and I may not remember the initial event, the initial conception. So, Steve, do you want to?
Well, I'm more than willing to jump in, but in a slightly different way. I want to begin by thanking Brooklyn Law School. Dean Cahill and Professor Porter have really been supportive of all this. I should underscore that in the 10 years I have been a visitor at Brooklyn, I have had wonderful faculty colleagues and wonderful support, and workshopped several parts of this book there. I've had great staff help, but especially I've had wonderful research assistants. My students at Brooklyn have been just super. And much of the work in the book reflects their diligent efforts in the library, and has really been a tribute to how terrific they are. And as Karen said, you know, I do have a background as a lawyer and still work as a lawyer. And so I'd like to begin with a story, actually. It's a story about Neil Armstrong, a real American hero. As I think most of you will recall, the first man to set foot on the moon. He died in 2012. The consensus is that he died because of medical error. He had an angina problem, and the doctors he consulted advised him to have an immediate bypass surgery. He had that surgery. A professor at Harvard School of Public Health and another at the University of Michigan said that that choice was probably not entirely sound, that addressing his problem with medication might have been a much wiser and less risky choice. However, hundreds of thousands of Americans have bypass surgery every year. And part of that surgery is to attach small wires to the heart after it's been restarted, and to use electric stimulation to make sure that it beats regularly. Eventually, most patients have those wires removed. They don't have permanent stimulation. And it was at this point that Neil Armstrong got into terrible medical trouble. When the wires were removed, he began to bleed in the area, the sac around his heart. And the best response to that is to take the patient into the operating room, open the chest up, take out that blood that seems to be leaking out, and stop the place where it's leaking. Instead, Neil Armstrong, astronaut, American hero, was taken to a catheterization laboratory, which could not provide the services that he needed. Again, reviewers said that this was deeply troubling error in all likelihood. The blood accumulated, it squeezed his heart, it produced eventually irreversible damage, and within a week, he died. Rather than any public discussion of medical error, what happened then was what really began, I think, Michael and I to go down the path of our book, not because of Armstrong, but because of so many stories like it. There was a secret $6 million settlement, and no one was told that Neil Armstrong had died because of iatrogenic injury, because of medical mistake. In 2019, the New York Times received an anonymous packet of about 93 pages. It was medical records and other materials about Mr. Armstrong's treatment. And what those 93 pages said was that there had been a disastrous mistake. Well, why am I telling this particular story? Because it is, as I said, how Michael and I came to be concerned about this issue. Hundreds of thousands of Americans die every year because of medical error. Medical error is an equal opportunity killer. It kills the rich and it kills the poor. It kills the famous and it kills the unknown. It kills the sophisticated and it kills the uninformed. We're not dealing effectively with this problem. Much of the problem, like most of an iceberg, is hidden beneath the surface, covered up, never identified, never discussed, never admitted, never addressed. That being the case, still we all know that there's a huge problem. We've known that since the late 1990s, when the Institute of Medicine, in a paper called To Err is Human, indicated to all of us that we have a serious medical error problem. We need to do better. We need to remove the cloak of secrecy. We need to adopt better solutions, incentives for careful care, disincentives for harm, effective government surveillance. New York, by the way, has a pretty effective government surveillance about bypass surgery, and that produced the safest bypass surgery program in the United States. We need candor more than anything else. As I said, I'm a lawyer, and as a lawyer, I've handled some medical malpractice issues or participated in teams that have. And what you see in that setting is that we haven't made the progress we should. Eventually, Michael and I, who had worked together on medical error problems before, approached me and asked if I might be interested in working with him on a book. He, as you may know, is a wonderful social scientist. He's a master with respect to data. And I knew that if I had him as a partner, we would have some very solid things to say, notwithstanding my presence on the team. And we really, I think, have. And we jumped into it and have produced what we hope is an argument to move us in the direction to seek greater safety. And I think that's my best way of saying how I got into this and how important I think it is. Michael?
Well, my memory of the initial spark is a little different, but close. My recollection is we were both attending some conference. It was probably the Society of Empirical Legal Studies. And in my memory, we were both in the same room together waiting for a program to begin. And we were just chatting. And the program was probably something about medical error or medical malpractice litigation. And for all I know, David Hyman was on that program, and we were there to hear what he had to say. And Steve and I were chatting, and we came to the realization that both of us believed that malpractice liability had not done the job, was not doing the job, wasn't going to do the job of reducing this enormous problem, this number 3 cause of death in the United States, and that we thought if the law was going to make a contribution, someone had to think about and get a big conversation going to get lawyers, legislators, and regulators thinking about what changes could result. Now, Steve said he's a lawyer, so he properly began with a story, with a case. I'm the data guy, so I'm in love with the data. Although, as Karen said, maybe love, some word, positive word like that, isn't the right thing to use for this. But what I want to say is that there is a community of people who are aware of the data. And the data came too late. Probably the earliest was in the 1970s and then into the 1980s. And by now there's no excuse for anyone to not be aware of it. And what I want to say is before the data came, and some of the earliest data were from the California Medical Association and California Hospital Association. And our book details these origins of the discovery. But before that discovery, it was very common for leaders in the healthcare industry to say that error is almost non-existent, very, very little error. And yet there is a gigantic amount of litigation, mostly frivolous, of course. After the data started to be discovered from the California Medical Association, Hospital Association, from the Harvard Medical Practice Study, and lots of additional work. I will hold up David Hyman's book because they have some enormously intensive study of the problem and efforts to do something about the problem. Although in the healthcare world and the healthcare lobbying world, the problem isn't seen. as patients who are being injured and killed. For them, the problem is lawyers suing. But a big part of the problem is that those lawsuits do very little. But although the world before the data allowed people to say very little error, lots of litigation, the world after the data were gathered and analyzed realized that there was and is an astonishing amount of harmful error, as Steve said, making it the number 3 cause of death in the United States, and that there is also remarkably little litigation. And as David Hyman and colleagues have documented, the reforms that have taken place have caused that fraction of cases brought by the legal system for medical error, they've made that shrink smaller and smaller and smaller. All of this says to me that business as usual in medicine is not fixing this problem, and business as usual in law is not fixing this problem. And since neither Steve nor I are doctors, we can't fix it in the healthcare world, though Hyman might be able to. But so we have to focus on the legal world. And so what the book tries to do is after some early chapters, I'm now going to describe the book for those who have not read it. And I wouldn't expect that at this point, I wouldn't expect most people on this Zoom call to have read it. But first 2 chapters introduce the issue of harm and patient safety. Chapters 3 and 4 develop the history of the problem, its discovery, its disregard, its eventual public unveiling, and the extent of the problem of iatrogenic injury. Chapters 5 through 8 examine the conventional legal response and the counter responses, which is a lot of medical malpractice law reform. And the final 5 chapters explore possibilities that we could think of other things that could be done and which the law might be able to play a part in promoting. And one thing we try to emphasize is that we do not think we have delivered the answer. This isn't the vaccine. We haven't said, here is the messenger RNA to create the vaccine that's going to stop all of the deaths due to medical error. But what we wanted to do was to get a conversation going so that others maybe can come up with better ideas. And I think as our talk today goes on, we'll get into some of those. But what we really wanted to do was create the occasion for lots of people to get into this discussion, to stop arguing about how can we make the world safer for doctors and hospitals so they don't have to ever sit down and be deposed by a lawyer. Forget about those law reforms. Let's talk about, and not just quibble about ways to tweak malpractice litigation. Let's start thinking afresh about what, if anything, the law can do to promote safety in healthcare. So for now, I'll leave it there and see where we go next.
So I'd like to actually raise maybe 2 questions before we invite Dr. Hyman into the conversation. The first is really, why don't we know more, right, about medical error? What's wrong with error reporting? that makes it so that there isn't a greater awareness of this problem? And then secondly, I just wonder whether both of you would touch a little bit on some of the solutions that you've actually thrown out, right, in the book. There's some that come to mind to me specifically, but I think I'll leave it up to you to sort of highlight one or two that might actually just round out a little bit of not only what's wrong, but maybe also a little bit of what might we do that could make things right.
Michael, would you like to begin, or shall I jump in? Whichever you'd like.
Why don't you talk a little bit about error reporting and why? Well, I think it's the question sounds to me like error reporting inside of healthcare, and then why doesn't the world know more about it? Perhaps two kinds of information that are not flowing. But so, Steve, you start with that. I'll pick it up.
Error reporting is a very tricky business, and you are asking people to tell you that they've made mistakes, that they haven't done their job properly, that they've jeopardized or harmed the individuals with whom they work. It's a very tough sell. And if you look across the first world, the European, American, Australian world, what you really see is a strong tradition of medical resistance to full and accurate reporting. And that's just human nature. And there's simply been no effective encouragement of radical candor. It simply hasn't happened. And that means that although there is a great deal of injury, there is not a great deal of talk about that injury. And it would have to be a radical reworking of the way we approach this problem for us to do a heck of a lot better. Some people have suggested that the best way to do that is to adopt the aviation model. The commercial aviation model has reporting with respect to near misses and actual damaging incidents that is totally insulated from the creation of liability and is used to respond to dangers in the operations of aircraft, and has had some effectiveness in that area. Unfortunately, the medical problem is so much larger that that approach probably is not practical. There are 30,000 observations filed with the NASA about unsafe practices in reporting dangers from aircraft operations. There are tens of millions of problems with respect to the potential harm of patients in hospitals. The volume is incredibly different. The language that is spoken to describe the injuries and risks and procedures and so forth has not been standardized as it has been in the aviation industry. We have a very large challenge, and we haven't yet worked out a way to solve it. With the computerization of medical records, with a variety of other forms of data concentration, we may eventually be able to do so. But so far, we simply haven't been able to do all that. And so we've decided not to talk very much about it, not to do very much about it. And that's, I think, where we still find ourselves.
And I think in terms of this information getting out to the public, out to lawmakers, and even out to medical students and new doctors, this is not something anyone likes to hear about. I was at a meeting at my university, Arizona State University. We have a lot of collaborations with the Mayo Clinic. And one Saturday, a bunch of research types from the Mayo Clinic and a bunch of research types from Arizona State, and I'm talking about biomedical engineering and virologists, people who want to come up with cutting edge medicine. They all came together, and I sat in on this meeting, and there was such enthusiasm about these new things they were working on or could be working on, and they were going to invent wonderful things to save lives, to make medicine even more effective than it already is. And someone in the audience, after 2/3 of the day had gone by, and it was not me, but someone else in the audience raised the question of, what about medical error? What could we do about that? And it was like a huge dark cloud had just come over the room, where earlier there was enthusiasm and excitement, and we're going to solve all these problems. No one wanted to say anything about it. The mood changed, and the audience the audience and the speakers did not recover from that moment until someone brought up some new high-tech thing that they could work on. And I also remember having been asked, I think this was shortly after the Harvard medical practice studies come out, or maybe it was just after those were summarized in the Institute of Medicine report. But there was a press briefing. And though I was not a part of any of those research projects, I was asked to participate in the press briefing. And the reporters at the press briefing were extremely resistant to the idea, even though it was coming from research studies and or the Institute of Medicine. They didn't want to hear it. They were very questioning of, how do you know these data are right? This can't really be, can it? I think here I will play the kind of psychologist I'm not and try to read people's minds. We all know we are going to need if we're lucky, we're going to need serious health care before our lives are over. And we don't want to think about the possibility that the health care itself is a threat to us. And what I would like to do, before we get too much farther into this subject, I would like to quickly summarize some of the data for those who may not be familiar with it. I'm going to try to do this without a slide. I'm just going to do this verbally. Imagine a hypothetical state of the United States with a population of 10 million. There will be 1.1 million, give or take, hospital admissions each year in that state. Of those 1.1 million, 36,500 will suffer an adverse event, which is the favored term for what we're talking about. Something bad happened that shouldn't have. About a third of those 36,000 will have been negligent adverse events. About half of those, so that's 11,000, about half of those 11,000 negligent adverse events are moderate to serious harm, of which about half are deaths. Out of those numbers, there will be, in that state, around 750 medical malpractice filings. There will also be a lot of settlements that never required the filing, where the harm doing was so glaring and obvious that all the defendants' insurance companies wanted to do was settle without there even being a claim filed. And those we barely see at all. Of course, as we all know, the vast majority of the claims will disappear through settlements or just being dropped or dismissed. And out of those 750 or so filings. There will be about 60 trials commenced and about 15 verdicts for plaintiffs. So 15 verdicts for plaintiffs. Total payments out of those 11,000 negligent adverse events, or out of those 5,500 moderate to severe negligent adverse events, there will be 280 total payments, with a mean payment in 2020 dollars, a mean payment of $415,000. So, and that's based on me taking the Harvard findings using medical records. So we're just looking at hospital medical records where a lot of bad news is never entered. There have been studies that have used on-scene observation. They put researchers in the hospital, on the wards. Those studies, and there's also something called the global trigger, which is a more computerized way of trying to scope out what's going on. These other studies that do not rely on patient medical records have found, depending on the study, 10 times as many, 15 times as many iatrogenic injuries and deaths as I just summed up for you. And that's just in hospitals. What about outside of hospitals? Very little data, but it appears that there is about, then again, as much harm going on outside of hospitals of a different kind, diagnostic errors, medication errors, but there are also freestanding surgical centers, which are not as good as hospitals by and large.
Before you go on, there are two questions that are posed. One is in the chat, and the other is raised by Professor Seebach, who had his hand up earlier. So let me just ask Professor Seebach to ask his question, and then I'll also just call your attention to another question that's in the chat related to the information that you're providing now.
Okay.
Thank you so much. Can you hear me?
Yes.
Yes.
Yeah. So hello to all my friends. I have so many on this Zoom meeting. I don't want to single anyone out, but I want to say that the authors of this book are incredible people. But here's my question. It follows Professor Porter's question about the pipeline of reporting. So I haven't gone back and reviewed the materials that you have in a while. It's been a while. But on the Harvard Medical School study that was just being referred to, I'm going to make my question the following way. It's easy for someone to say who studies tort law that it's very clear that there's a vast number of objectively knowable events that are adverse events. I mean, there are misadventures in there, and the knowledge that there's been a misadventure is often easy to determine after the fact. However, one thing I thought I recall from the Harvard Medical School studies is that there was actually a great deal of controversy about the readers of the files, about whether or not they could ascertain whether or not an adverse event was the result of carelessness. And of course, we have far fewer actual episodes examined for whether they're careless for lots of reasons. But even when we do examine them, there are questions of basically are limitations of knowledge. It is sometimes hard to know whether or not an adverse event is the result of carelessness or not. That's at the nub of negligence law. And I'm just wondering, is that one reason why we don't have as much robust data? I mean, maybe we do. You said 1/3. I'm kind of wondering, that's not what I recall from the Harvard study. I thought there was a lot more fog there than what you suggested.
Well, I'll say, I can say a few things based on my fading memory. One is that identifying the adverse event was easier than saying whether it was the result of negligence or not. They defined adverse event as an outcome that was unexpected, something that ought not to have happened under the circumstances and was not a consequence of the underlying disease or injury that was being treated. And they had multiple screeners, reviewers, I think 2 on each case. And if they did not agree, a third person came in. So you're quite right that these things are not clear, crystal clear, but in their large report on it, which was a very fat, published, not published by a commercial publisher, they gave a lot of data showing the extent of agreement or disagreement. They set the threshold for declaring an adverse event fairly high, because they didn't want there to be much argument about what they caught in their net, so that whatever they caught, you could be confident existed. There might be more. And a couple of those same authors published a subsequent article in either JAMA or the New England Journal of Medicine, saying if we had used a lower threshold for declaring an adverse event, here's what those numbers would look like, and they would have been larger than they are. But I think the hardest part, because I think it's always the hardest part, is to be able to say whether what one is dealing with is negligence or not. But on that, I will point out that these were the people making those calls in the Harvard study were medically trained people, not legally trained people. So I'm not sure what the implication of that is, but as we all know, you could pick a plaintiff's lawyer and a defense lawyer, or 2 lawyers to play those roles, and they could get a good argument going about whether most, I don't know about how many, but a large number of those injuries were negligent or not. But the final point I'll make on your question is, it's really the legal community that wants to categorize these as negligent or non-negligent. We patients and the researchers, what they would really like to stop is injuries to patients that ought not to be occurring. And our book ultimately tries to move away from litigation as the answer to the problem.
Let me second what Michael finished with, and I think that's the most important point. I mean, Tony underscores something that we for decades, perhaps a century actually, have thought as the real barometer or the real measure, and that is our declaration of negligence, the failure to follow a standard acceptable in the profession in that particular locale. That's not the issue. The issue is harm. The issue is death. The issue is mistakes. And whatever way we can, we want to avoid them. We want to address the systems that produce this problem and change those systems in effective ways. Negligence as a label has not had that effect. Even in Neil Armstrong's case, which I believe to be quite clear, actually, one can still say that there were people who said it wasn't negligence. I don't care about that. I am saddened to lose this American hero because of a mistake that was clearly made. And that's the more important point, I think.
So Stephen, let me just recognize one question that's in the chat, and it's really just a matter of clarification. Professor Marumba has asked whether iatrogenic harm includes overtreatment or unnecessary treatment, because under our system, such treatment is profitable. So that's the question. I mean, it raises a question that I have, which is about the money, right, in all of this. I'm going to throw that out there, but I'm going to ask while you're answering to have Professor Hyman highlighted and brought into the conversation at this point. Thank you.
David, would you like to start us off?
Well, why don't you answer the technical question and then I can make some remarks and we can go from there.
Where I was headed, as I was going through my numbers, is exactly where the questioner wants to take us. I told you what the medical records showed, what the on-scene observational studies in hospitals suggested, that it was multiple times that. I had said that hospitals aren't the only place where healthcare is delivered. And then the next category I was going to offer was healthcare fraud, where people are being given treatments that they don't need. They're being given bypasses that they don't need. And you might never have anything happen in those treatments to those patients that would be considered an adverse event. Everything goes well. They have their operation that they didn't need. And those never get counted in the iatrogenic injury counts, but I would want to add them in there. And then last but not least, if defensive medicine exists in anything like the magnitude that surveys of physicians tell us it does, I'd want to add those in as healthcare fraud. These are violations of medical ethics, violations of law. They're signing a form saying they gave a patient what the patient needed. This was for the benefit of the patient, when the doctor is acting for the benefit of the doctor. Because if they're not, then it's not defensive medicine. And some of those result in harm. So they don't usually get counted, but I would add them in as part of the problem. David.
Yeah, so first of all, I want to thank Michael and Steve for writing the book and for inviting me to be the commentator, and to Brooklyn Law School for putting this on. Now that I'm teaching at a law school in Washington, D.C., I've learned the way that you evaluate books in D.C. is you flip to the back of the book and look up your name in the index and see how many times you're mentioned. And then you look at those pages and you see whether the authors say nice things or mean things about you. So judging by that criteria, I actually do quite well. They cite me and my co-authors a bunch of times and they say nice things about us. But I think, that's not the right way to evaluate a book. Obviously, the authors have really done something quite remarkable and exceptional here. They've synthesized a vast literature on patient safety and on medical error, and on medical liability. And those are sort of, Venn diagrams that overlap to varying degrees depending upon who's writing about them. But even more difficult, they've made that literature accessible to a non-specialist audience, and offered a range of possible strategies for making things better while recognizing the institutional and political constraints that have made it difficult for us to make progress on these issues. I'm teaching a seminar on medical malpractice in the fall. I'm going to be assigning this book because it's so good. So if you're looking for revealed preferences, that's objective evidence. The book itself is a really wonderful description of the importance of information and incentives in the way our healthcare system operates and why attempts to reform it have foundered. Neither markets nor regulation have made much progress on the problems of patient safety and quality of care. In a book entitled Bureaucracy, James Q. Wilson noted that, quote, regulation writers find it much easier to address safety than health hazards. The former are technically easier to find, describe, assess, and control than the latter. The challenge, of course, for Sachs and Landsman is that they picked a problem at the interface of safety and health. And if these problems were easy to fix, we'd have done so already. Now, the problem was fixed in anesthesiology, a case study that Sachs and Landsman talk about. And there, the consequences of patient harm someone was perfectly fine, got put to sleep and didn't wake up, or woke up brain damaged. They're easy to observe, they're hard to argue with, and they're pretty readily traceable to errors and omissions that took place at a particular place and time. And liability actually played a role in making that problem visible and worth fixing. Anesthesiologists responded to the tort signal. But in lots of other areas, as Sachs and Landsman relate, you make more money by mistreating patients than by delivering optimal care. There's not a business case for quality. It's as if General Motors got paid more if their cars broke down than if they were successful, because they got paid to fix them then. We don't see this in ordinary consumer markets to nearly the same degree. As Sachs and Landsman point out, that's because law plays an important role in the background by forcing people to internalize the costs of bad decisions. So why is it that healthcare is different? Well, I've spent the last 20 plus years writing about various aspects of that issue. But rather than talk about my work, let me highlight 2 chapters from the remedies section of the Sachs and Landsman book, because I think they show both how hard this is, but also the creativity that the authors have brought to this. Now, in their chapter on regulation and engaged surveillance, as opposed to, I guess, casual or isolated surveillance, Sachs and Landsman talk about the problem of evaluating cardiac surgery programs in surgeons, and how attempts to do that and improve quality and outcomes met with, at best, mixed success. As they note, for cardiac surgery, the improvement, if we observe it, is only with the real outliers, right? The people who are just above the mean or the median, depending upon which one you're calculating, sort of look at this and say, well, I'm fine. And even if I'm not, there's a problem with the measures, so why should I pay any attention to it? The far outliers, on the other hand, nobody goes to medical school to be below average. They want to get back closer to the mean. And over time, that can result in a sort of virtuous circle or cycle. We actually, in another paper that Sachs and Landsman don't cite, found similar results when we look at hospital responses to infection reporting. We also found evidence of gaming, which they talk about as well. But there are ways in which the disclosure of information can motivate providers to do a better job if the disclosure is public, and if the providers think that patients or someone with the power to punish them will care about it. The sort of flip side of that is if it's not public, or if it's too hard to interpret, right? Do we want a high rate or a low rate? Which one is good? You can't game that with stars, but some people look at, if they're not sophisticated, they look at hospital readmission rates and they say, oh, you've got a high readmission rate. That's good. That means you're really careful, rather than that's bad. You didn't do a good job in treating people the first time. So when you're running, consumer disclosure regimes, it's really important to think about what can go wrong. Now, you can't do any of that without data, but data is really hard to come by. We have really good billing data. We don't have really good access to clinically rich, comprehensive data. And that's going to be necessary if you want to persuade people that you're actually measuring the right thing and doing it in the right way, and you've controlled for all of the things that can complicate the kind of quality measures you're using. Now, if I can share my screen, let me just see if I can do that. I wanted to show you just briefly some actual data to sort of make the point of the complications here. First, let me just continue Michael's generous pitch for my book by highlighting the book that came out 3 years ago with Charlie Silver, and the book that came out last month on medical malpractice litigation. But I want to talk about a new paper just very briefly. What we did is we identified 221 doctors in Illinois and Indiana that had truly horrendous records for malpractice and disciplinary action. They had to have both of those things and more than one of each, okay? And then we matched them with 221 doctors that had perfectly clean records. And we did something very sneaky and underhanded, which is we went and looked up their online reviews that patients had given these two groups of doctors, okay? And if there's anywhere that you would expect to find a difference. We basically rigged it to try and find one. And if you look at the actual results, it's pretty modest. The questionable doctors, the doctors that have the bad records, are in gray. The control doctors are in white. So they have a slightly better number that get 5 stars on a 5-star scale. But the overall distribution basically completely overlaps. So this should raise some obvious questions about the utility of these sorts of online evaluations in steering patients away from doctors with problematic records. So for me, the most interesting chapter is the one on IT, which is what the book ends with. Typically, writing on medical malpractice only gets into IT in terms of the risks that new stuff creates. So telemedicine, gee, it's nice for access, but it can create all sorts of liability concerns because you're only looking at people on the camera and you're not seeing them in person or laying hands on them, and you're geographically remote, and maybe you're using software that doesn't work, et cetera, et cetera. The really interesting thing about this book is Sachs and Landsman, I think, embrace IT and technology as a possible solution to some of the problems, not a panacea, creates its own set of risks to be sure. But this is not the kind of chapter you would find in a book that was focused only on medical malpractice. It tells a hopeful story about the potential of technology to break down an insular business and serve consumers, patients, pretty much everybody better. So wholehearted endorsement of the book. I'm not by nature a jealous person. I'm deeply jealous of Michael's piece in the Penn Law Review on the tort system. And now I can add a second thing by Michael and by Steve as well to my list of things that I wish I had written. So let me stop there and we can go on. Thanks very much.
Karen, do we want to go back to questions, or there was one that you had left on the table about the kinds of things that might be able to help with these problems. And, David has teed up some of that, and we could go further there unless there's more in the chat or other things that you'd like us to do.
So I think that would be a good place for us to go for right now. And then we can, I'll invite people to start raising their hands and we can go to questions and answers.
I sort of have been thinking about this because I think it's very important, if we're going to do something different, to have categories of responses that have a real chance of doing something. And, sort of one of the areas that we focused on is incentives. And America is a land of incentives that are financial. And the question is, how do we introduce those effectively into healthcare? And I think that there are ways, and we may be beginning to see them. The 30-day no readmission to the hospital for a variety of kinds of injuries seems to me to be a pretty good idea and a pretty straightforward kind of response. Of course, there are sort of problems with it, and it needs to be prevented from reaching too far, because there are certain chronic kinds of challenges that will produce rehospitalization. But as a general rule, it's a pretty good one. No pay for injuries that are clearly of a sort that we would call negligence or serious kinds of harms. And in fact, responsibility to pay for fixing them also seems to me to be the kind of thing that in a incentive-filled system, you certainly want to go to, that we really need to go to. David has mentioned the engaged surveillance kind of idea. It was adopted in New York, and public discussion and rating of hospitals that were dangerous and producing outlier levels of harm in cardiovascular bypass surgery was incredibly effective. And We have a very large number of risky sorts of procedures, cancer resectionings, back surgeries, knee replacements, variety of others. It's time to take a close governmental look at those and to make known who the outliers are and to address the problems that they produce, the injuries that they produce. Third, I think we need greater candor. We need a responsibility on the part of the medical system to tell patients when they've been harmed. And the evidence suggests that if you do that, you get better results in terms of patient feelings, responses, and even reductions in litigation. We need to go in those directions. The ideas are out there. They just have not been pursued for a variety of reasons.
I will throw a few things out there. I taught a seminar this past semester in medical, well, basically on this book. And one of my students is a physician who's been a hospitalist for the last 10 years. And it was interesting to see his responses to a lot of the problems that we discussed revealed to me how little the system is designed to solve problems in a going forward way. So for instance, the most glaring of these, I think, was we were talking about reporting. How could you make it, how could you help doctors, nurses, others feel more comfortable reporting on an error that occurred, but perhaps harm did not result, a near miss, or other things that might not make it into the medical record, might not be obvious, some reporting system. And the class, of course, this was all done on Zoom, but we turned to our doctor student colleague. So here's a doctor after 10 years of practice, goes to law school. I had to ask him what the problem was, but we asked him, how would this work in any of the hospitals? He's a hospitalist. He works in a number of different hospitals. How would you report an error in one of these hospitals? He said, I don't have the slightest idea who or where or how I would offer such a report. No one's ever told us. I don't think they collect any of that. And so I want to say a little bit about the system issue. This is relatively newly discovered by people who think about healthcare and medical error. Other industries discovered the idea of redesigning the system to make it hard for accidents to happen, hard for error. They haven't achieved impossible, but a century ago, they were starting to work on this. So for example, instead of telling me when I'm working at my drill press, don't put your hand under this thing, it'll do a lot of damage. Just remember that, think about that all the time. Don't get so lost in your work. Well, you redesign the machine so that my hands can't. Some of these machines, you have to push 2 buttons to get it to work. So that forces you to get your hands out of harm's way. Guess what? Lost fingers and crushed hands stop happening at such a high number. So there are thinkers in the patient safety movement who have turned their attention to the system. And I think the system is tied into malpractice litigation, and it's tied into incentives. And I think our incentives are not such as to encourage the systems. So for example, to the extent that the focus of malpractice liability is on individual physicians, you are aiming it at someone who is in no position to change how the hospital is run, what equipment they are using. David mentioned the anesthesiologists. I think in some hospitals, they had to pressure the administration to obtain some of the new equipment that they needed to more closely monitor patient oxygenation, for example. So you've got to get the administration doing these things. But again, as David mentioned, the administration is sitting there. If I'm the CEO of a hospital and I've got a budget to balance, and I realize that when patients are injured, we make more money than when things go smoothly. And now someone wants me to invest money to improve the safety in my hospital. We'll have to research it. We'll have to hire experts, perhaps. We'll have to train everyone in the new methods. We're going to have to invest millions to make our hospitals safer. And what is my reward for that going to be? We're going to bring in less revenue. So the incentives there are totally backwards. And yet the people who are in the position to help change the structure of the organization, the operation of the organization, are not the people who are feeling the bite so much, or at least not complaining about it as much. Let me say one other thing about system and incentives. One example I came across, or one study I came across when researching material for this book, was the example of a seriously ill child who is brought to a general hospital for the emergency room. And if that child comes from a family that has good insurance, that hospital will want to keep that child there and not transfer the child to a children's hospital, which probably would be a better place for that child with that serious problem. So those children will be kept at the general hospital. Now you bring in a child with an illness that might not be as serious, but the family has no insurance, maybe Medicaid if they're lucky. That hospital would love to transfer that child, and does transfer that child, to the children's hospital. So the children's hospital is not getting the patients transferred to them that they could do the most good for with their specialized capabilities. And the children with the more serious problems, but the good insurance, are kept at the general hospital where they won't get as good care. So the system goes outside of the hospital. It's these interlocking things. And I do have to say again, since David and Steve and I are praising each other, I became it is reading David's work that has enormously sensitized me to the problem of incentives and getting them right if you want to change behavior.
So thank you all. So I think we want to just see if we can wind down at this point. We're at 7:32. I think we've had a very rich discussion. Let me just ask for any last words at this point.
Well, I want to boast on behalf of Brooklyn Law School. I taught a seminar with respect to these materials and used the book when it was in draft last year. So we're ahead of Arizona State, we're ahead of Georgetown, and it's my hope that, we're going to create a group of young lawyers and legal thinkers and legislators who will go out there and start to grapple with these problems in a new way.
I just want to call attention to Professor Engstrom's note in the chat that she is absolutely correct that the birth injury funds in Virginia and Florida have had difficulties, including a series of recent articles about the Florida funds, which have behaved kind of like bureaucracies would tend to behave. And I want to just close by thanking the authors again for writing a wonderful book and inviting me to comment on it.
I will close by also thanking Brooklyn Law and David for joining us, and Karen for organizing and moderating. And I want to say to everyone in the audience that I want to repeat that we do not think we have delivered any kind of final answer to the problem. And I hope that some of you will be drawn into helping to think about these things and solutions for them. Thank you.
Thank you all for joining us this evening. It's a wonderful book. Again, it's available on Amazon and on Barnes & Noble. It's a shameless plug on my part, but I think well worth it, well worth a read from all of you.